Let's discuss paragraph 4. It's long title, Conveyance, Closing, and Possession. Okay, closing occurs when the seller conveys the property to the buyer. The buyer and seller are agreeing on a date when that will happen. It can actually happen on or before that date, but it can't happen after that date without a signed extension by both parties. So if it comes up to closing date and one party can't perform, then the contract is expired. It talks about how the conveyance will be, and that's a bunch of legalese for you. That's what the attorney will check all the easements and reservations and right-of-ways. It does say the seller agrees to convey marketable title. And marketable title is basically that it's clear. There are no liens against it. There's nobody coming and saying they actually own the property rather than the seller. It also says that seller is going to give a general warranty deed. There are general warranty deeds, there are limited warranty deeds, and there are actually quitclaim deeds. A general warranty deed says that all of these things we talked about, that the seller owns all the property, there are no liens against the property, there are no lawsuits against the property. The seller is saying that's true from me all the way back to Adam. Now, I'm exaggerating, we don't have records all the way back to Adam, but so you'll remember. A limited warranty deed just says, I know there's a seller saying, I know there are no liens, there are no bad things while I've owned the property. A quitclaim deed just says, if I have any interest, you can have it. A quitclaim deed, not very powerful, it doesn't have any warranties at all, but it will release any title that somebody could have to a piece of property. The next thing for us to talk about is the names on the deed. There's a blank for you to put how you want your name to be on the deed. Please put your name exactly as you want it. If you go by Bobby and your name is Robert W. when you do things legally, then please put Robert W. there. Okay. If there are two people on the deed, you can own property in one of two ways. One is tenants in common, and the other is what we call joint tenants with right of survivorship. Tenants in common means that if you and I were to own a piece of property together, and it's by tenants in common, then if I die, my will would say who gets my half. Of course, same thing, your will would say who gets your half. But if it's joint tenants with right of survivorship, when I take my last breath, it's automatically yours. So it avoids probate. Lots of people like to take it as joint tenants with right of survivorship. There are some downsides, but not many. If you decide you want to take the property with joint tenants of right of survivorship, if you would just put JTWROS, joint tenants with right of survivorship, just the initials in that blank, your attorney will know how to prepare the deed. Otherwise, the attorney will probably call you and discuss the options with you of which way you prefer. Now, at the end of this, it talks about what the seller will give, okay, and what they'll do. You'll convey possession, vacant and reasonably clean. Okay? Different people have different ideas of what's reasonably clean, so you can require professional cleaning. When my mother was alive, her house was sterile. She was an operating room nurse. That's not necessary, so you'll know what you like. Free of debris, and then also they'll give you any keys, remotes, remote controls, any documents you have, seller, that should go to them, manuals, equipment, any of those type things, similar items. It's very, not only required by the contract, but very nice if you would pass those along to the buyer. Because actually, what are you going to do with them anyway?